She woke up on a Tuesday morning to find her PayPal account completely frozen, not because of a court judgment, not because of a filed lawsuit, not because of any debt she had knowingly agreed to. A financial hold had reached into her personal life before a single piece of legal paperwork had been served. And the company that put it there? She had never borrowed a single dollar from them. Here is the full story of how one signature, signed under false pretenses, threatened to attach $52,000 in business debt to a woman who never owned the business. To understand how we got here, we need to go back a few months to a moment that felt completely ordinary. Our subject, we'll call her Sarah, was working as an employee for a small LLC in Texas. She held no ownership stake. She had no management authority. She was there to do a job and collect a paycheck. One day, the business owner approached her with a stack of paperwork. He explained it simply: payroll processing forms, standard onboarding, and here's the detail that mattered most to Sarah at the time, a $1,000 bonus. She was in a financially vulnerable place. $1,000 meant something. She signed. She did not know what she was actually signing. What she had actually signed was a personal guarantee on a merchant cash advance agreement. The business received $35,000 in funding. The total repayment obligation, $52,000. Every dollar went to the company, not to Sarah, not to any bonus. The business got the cash. She inherited the liability. From Sarah's perspective, this was fraud from the first moment. She was told on multiple occasions that she bore no personal responsibility for the paperwork. The documents listed her title as operating partner. She was never an operating partner. Her photo, pulled directly from her Facebook profile without her knowledge or consent, was used in materials submitted to the lender. She believes her identity was used as a tool to secure financing. She never agreed to guarantee. But step into the lender's position for a moment. Merchant cash advance companies operate in a high-risk environment, lending to small businesses that traditional banks routinely reject. They protect themselves with personal guarantees precisely because LLCs can dissolve, go bankrupt, or simply vanish. From the lender's view, they have a signed agreement with a named guarantor. They followed their standard process. Whether that signature was obtained honestly, that may not have been their concern. And then there is the business owner, the person who set all of this in motion. A charitable reading. He believed the LLC would cover any repayment and the guarantee was just a formality. A less charitable reading. He deliberately used a financially vulnerable employee, misrepresented what she was signing, and put her financial life on the line to fund his own operation. Courts have seen both versions of this story. The paper trail determines which version wins. Here is what makes this genuinely complicated. Merchant cash advance agreements are engineered to be difficult to escape. The personal guarantee exists specifically because LLCs offer their owners legal protection, and lenders want to reach past that protection. If the person signing was deceived, the lender may argue they had no way to know. So the question becomes, when fraud happens between an employer and an employee, who absorbs the cost? The innocent guarantor, or the lender who failed to verify her actual role? Think about that for a moment. What would you do if you discovered your name was attached to $52,000 in business debt for a company you didn't own? Drop your answer in the comments, because this case gets even more complex from here. Let's break down the legal terrain, because there are 3 separate legal frameworks colliding in this case. First, merchant cash advances. An MCA is not technically a loan, it is a purchase of a business's future receivables. That distinction allows MCA companies to sidestep many consumer lending regulations, which is precisely why they can act so aggressively. When you sign as personal guarantor, you step directly in front of the liability shield an LLC normally provides. Second, the UCC Lien. UCC stands for the Uniform Commercial Code, commercial law that governs financial transactions across all 50 states. Lenders file what's called a UCC-1 financing statement to publicly declare a security interest in a debtor's assets. The critical question here: can a UCC lien filed against an LLC legally freeze a personal PayPal account belonging to the guarantor? The answer depends entirely on what the guarantee agreement says. If it grants the lender a security interest in personal assets, it may hold. If not, Freezing a personal account before any court judgment may be a pressure tactic, not a legitimate legal hold. Third, fraudulent inducement. Texas law recognizes that if you were deceived into signing a contract, if someone made material misrepresentations that caused you to agree to something you never would have otherwise, that contract can be voidable. Keyword: voidable, not automatically void. Sarah must raise that defense affirmatively in court with evidence, which means she cannot afford to wait passively. Here is where the story pivots. Sarah discovered she had retained access to the email account the business owner used to orchestrate this deal. She is now carefully preserving every document she can find, contracts, correspondence between the owner and the lender, any communications that show her role was misrepresented. In financial fraud cases, courts love paper trails. If those emails show the owner explicitly described her as an operating partner, knowing that was false, that evidence could unravel the entire agreement. There is another layer that cannot be minimized. Her photo was taken from Facebook without consent and submitted to a lender as part of a financing application. Using someone's image and personal identity to obtain business financing without their knowledge is identity fraud. Depending on how that information was transmitted, federal wire fraud statutes could apply as well. Filing a report with the FTC at identity theft, Gov, and with local law enforcement creates an official record, one that becomes critical evidence if this escalates to criminal proceedings. The jurisdictional issue adds one more complication. Sarah is in Texas. The financing agreement specifies New York law and New York as the legal venue. This is standard in commercial contracts, lenders draft agreements that favor their home jurisdiction. But courts sometimes reject these forum selection clauses as unconscionable when the opposing party had no real ability to negotiate the terms and the imbalance of power is obvious. Sarah's attorney may be able to argue this case belongs in Texas, not New York. Sarah has a MetLife legal plan through her employer. She tried to use it. The attorneys declined. Their standard position is to wait until she is formally served before engaging. This is frustratingly common, and it is exactly the gap these lenders exploit. The freeze is already in place. The lien is already filed, and the person it targets is still standing in legal no man's land, waiting for a lawsuit that may or may not come. The pressure is the strategy. This is the moment where most people panic, and panic is precisely what aggressive pre-litigation tactics are designed to produce. The frozen account, the lien filed before any judgment, these are pressure tools. A desperate settlement is worth far more to these lenders than a prolonged legal fight. Understanding that shifts everything about how Sarah should respond. If this reaches a courtroom, Sarah's core defense is fraudulent inducement. She was told the documents were payroll forms. She was explicitly told she bore no personal liability. She was assigned a title, operating partner, that was fabricated for the lender's benefit. If her legal team can produce the emails proving those misrepresentations, the personal guarantee becomes voidable. The lender's claim then falls entirely on the LLC, which may have no assets remaining to collect from. The business owner, meanwhile, faces a separate legal reckoning entirely. If it can be established that he used Sarah's identity without her consent to obtain $35,000 in financing, that is not a civil dispute. That is a crime. Texas Penal Code Section 3251 covers fraudulent use or possession of identifying information and carries serious penalties. Federal wire fraud statutes may apply if any of the communications cross state lines electronically, which, given the New York venue, they almost certainly did. As for the frozen PayPal account specifically, a legal demand letter is not a court judgment. PayPal froze the account as a precautionary response to the lender's UCC claim, but they are not required to maintain that freeze indefinitely without a court order. A commercial litigation attorney can challenge this freeze directly, potentially restoring Sarah's access to her funds while the underlying dispute is fought out in the appropriate forum. Here is the bottom line. Sarah has real defenses and real legal options. The outcome depends almost entirely on documentation, the emails, the contracts, the communications that show her role was fabricated and her consent was manufactured. The lender may be acting in technical compliance with their agreement, but an agreement obtained through fraud is not the same as an agreement freely entered. That distinction is what courts exist to sort out. In terms of immediate next steps, attorneys familiar with MCA fraud recommend 4 actions in this order. First, preserve everything, every email, contract, text, and document backed up in multiple places. Second, file identity theft reports with the FTC and local law enforcement today, not after a lawsuit arrives. Third, seek a commercial litigation attorney specifically experienced in UCC disputes and fraudulent inducement, not a general practice firm. Fourth, formally contest the PayPal freeze in writing, citing the absence of any court judgment authorizing it. Cases like Sarah's are more common than most people realize. Merchant cash advance fraud, particularly schemes that recruit employees, family members, or friends as unwitting guarantors, is a documented and growing problem. The FTC has pursued enforcement actions against MCA companies for deceptive practices, but the individuals who are deceived into signing often suffer quietly, unsure whether fighting back is even possible. It is, and the earlier they act, the better their position. If you or someone you know has been listed as a personal guarantor on a business debt you did not knowingly agree to, the time to act is before a lawsuit is filed, not after. We have linked a free legal resources guide in the description below, including how to locate attorneys who handle UCC disputes and fraudulent inducement claims in your state. If this breakdown helped you understand how the system actually works, subscribe to Courtroom Chronicles. Every week we cover the cases that reveal what the law looks like when it meets real life. And tell us in the comments, what would you do if your bank account was frozen for a debt you never agreed to? We read every single one.